Good afternoon and a very warm welcome to today's IIEA webinar on protecting consumers in the digital age. My name is Joyce O'Connor and I chair the digital group here at the IIEA. And it's my great pleasure to welcome our distinguished speaker today, Professor Marie Jull Sørensen, Associate Professor and Vice Dean of Research at the Department of Law at Aalborg University in Denmark. Marie, you're very welcome, and we look forward very much to your presentation. Thank you very much for being with us today and taking time out of your busy schedule. We appreciate it very much indeed. Marie will spend about 25-30 minutes in our presentation, and following that, I will go to the questions and answers. So please join our discussion using the Q&A function at the bottom of your screen. And feel free to send in questions or comments during Marie's presentation. I'd very much appreciate if you'd give your name and affiliation when you ask your questions, and thanks very much for that. I'll come to them once Marie has finished her presentation. As is usual, today's presentation and Q&A is on the record. Please feel free to join the discussion on X using the handle @IIEA. As our lives, economies and service moves increasingly online, ensuring consumer protection in the digital space has never been more critical. From safeguarding data privacy to addressing manipulative and addictive practices and patterns, the digital world presents both enormous opportunities and serious challenges for consumers and regulators alike. In her address, Professor Sørensen will discuss consumer protection in the digital age, exploring the underlying rationales and regulatory approaches. She will discuss the upcoming proposed Digital Fairness Act. And the Digital Fairness Act, I think, is very interesting because it's proposing, or the EU is proposing, to strengthen consumer protection in this digital environment, complementing existing regulation like the Digital Service Act and the Digital Markets Act. So its aim is to promote greater fairness, transparency, consumer empowerment in digital markets, and it specifically targets deceptive and addictive practices, ensuring that consumer rights are upheld in an increasing digitalized environment. But as Marie will tell us in her presentation, it's still only a proposal. But it is expected to be formally proposed in 2006, going through an impact assessment and public consultation, maybe during the summer, but that's not totally clear as yet. Marie will also look at guiding principles and model rules on digital assistance for consumer contracts and examine the whole area of what is consent. And she'll ask a very critical question: when and how does the consumer consent? And so our presentation is going to be very intricate and complex, but one that really holds a lot for the future. And we're very honored to have you today, Marie, as a leading expert in consumer protection, digital regulation and public policy. As an associate professor and vice dean of research at the Department of Law at Aalborg University in Denmark, Marie is published widely and has written several articles and contributions in Danish and English on consumer law, specifically in relation to challenges posed by the new business model that we're all operating now in the digital marketplace. She's prepared a report on digital fairness under the auspices of the European Law Institute. She chairs the Nordic Hub there and is a rapporteur on the e-Justice portal and a co-rapporteur on the ELI's project on automated decision-making. Marie, it's my pleasure to hand over to you now, and thank you very much.
Thank you very much, Joyce, and for this very, very nice presentation. And I will just, as always, try to see if I can share my screen without any too much burden for everybody. And so I will ask you now, do you see my screen now?
Yes, we do.
Good.
Yeah,
good.
That's great. Thank you.
Thank you. Well, thank you very much, and thank you for asking me to do this. It's always very interesting to talk about the protecting consumers, and it's something that just keeps on giving new challenges because the society changes, and now we have the digital age. We have had that for a while, but it keeps expanding. It keeps giving new business models, possibilities. So, and I actually, Joyce already mentioned my agenda, I will not go through that. And of course, we tested this before, and now I cannot switch my slides, but I'll try to do it here. Oh, here we go. Good. So, like you can see on the agenda, definitely what Joyce said, I will try to touch upon everything here. Uh, Maybe you will think some of it I will skip through very briefly, but then hopefully we can return to that in the discussion. So let's start with the underlying rationales. Um, as you all know, a consumer is one who acts outside his trade or business, and a trader is one who acts inside his trade or business. This is not something that's going to change much. But I would like to talk a little bit about the average consumer, because specifically in the digital environment, we might see a switch in how you view the average consumer. It's the benchmark where you target your advertisement and your information to, and then you presume that this average consumer is able to understand this, right? This is based on an economic, rational person view. But as you all know, we are not rational people. We behave quite differently from being rational, actually. So we have a lot of cognitive bias that will show in the way we act in the market. But we have used this average consumer as the benchmark normatively, and the courts have used this benchmark. We might see a little change now. I would say we saw it in TCAN, a ruling from the ECJ. And we have seen also academics coming out and saying this is not a way to go, because in the online environment, businesses, they do take advantage of consumers having cognitive bias. And if the businesses rely on this way of behavior, then our rules should also kind of have that same standard if we when we apply the rules. So this is something we will have to take into consideration when we go into the online environment. Also, I'd like to make a couple of comments on how we view the consumer, whether it's a vulnerable person or it's a competent person, because this is dependent on how we want to regulate this area. And we see both views in the rules as of now, and also we will see it in the future. But just to kind of make us think about this a little bit. So if you view the consumer as vulnerable, you will have this paternalistic approach to consumer protection. You will protect them as they were children. You would kind of curl all obstacles away. You will protect them from harm and so on. So I call this the silent protection, right? But if you, on the other hand have a more competent view of the consumer, you will empower them. You will give them information, or you will give them rights, and then they can make free choices. Then they themselves can make actions and protect themselves by giving them information, for example, or rights. And we see this, of course, in the information paradigm, which is the paradigm of the consumer protection quite extensively. But we have both views in our legislation. But what I see in the future, and also with the Digital Fairness Act, probably will do more than other. It will see the consumer as vulnerable. So it will aim at protecting consumers and not empowering them necessarily. Well, whether that's a good approach or not, I cannot say, but it is the fact that it's easier for us to see what happens in the physical world compared to the online world. So we might be just more vulnerable as a start in the online environment because we cannot see behind the screen. So we need somebody to protect us. Maybe that's of course a political choice, but that's two different ways of viewing consumers, and then thereby two different ways of looking at legislation in the coming future. We also see some tendencies to move away from solely protecting consumers' economic interest. This was the starting point, right? Being the consumer being part of the internal market. So that was the economic interest that we had the need for protection of. We see a little mix over to the more social protection, seeing a consumer not just as an economic being, but also as a social person. We see this mostly maybe in the academic world, trying to elaborate on what is going on in the Court of Justice cases and so on. But we also see it in the DSA, for example, the Digital Services Act, where they both talk about democratic rights, they talk about privacy, and they talk about the economic interest of the consumer. So we might in the future also see more of a mix between all these considerations that you can have for consumers, not just as market players. And in line with that, we can see that, well, a high level of protection is written into the EU Charter, the Article 38. So this is a fundamental right. And we actually also see this specifically in the last case I put here on the slide, in the SPCI case, where they refer in a case regarding unfair terms. They refer both to Article 38 of the EU Charter, and they also refer to Article 7, which is about the right to housing. So here they also mix unfairness evaluation of a term with both, consumer protection as the economic interest, but also with more other fundamental rights, or maybe social protection, as we can call it. We also have an interesting case in Astrocom and also other cases. Here, the ECJ, the European Court of Justice, says to the national courts, if you have to apply ex officio public policy rules, then you also have to apply ex officio consumer protection coming from the EU. So basically, they're saying consumer protection is public policy. And at least in Denmark, this is very, very intrusive in our legal system. This is not how we view normal material rules on consumer protection. So, but it's there, and the Court of Justice has mentioned this several times. So we are looking at an area that has kind of a special status, you could say. Regardless of this special status, they still have to be a balance between consumer protection and giving the businesses a possibility of conducting their business and having a business and starting a business. So if we want more competition in different areas, for example, big tech, we're talking big tech because they are big. Maybe it's hard to have competition because of these rules. I know this is a big issue at the moment, at the moment, and it will probably become even bigger when we apply more rules in this area. Yes, and lastly, we do acknowledge that there's a difference between the need for protection in the physical environment and in the online environment. So that's also the rationale behind this. Yes, very briefly, consumer protection is made up by basically standards. That's a starting point. We have good practice standard, due diligence standards, fairness standards, and so on. And that's a very pragmatic way of regulating, right? But it's also very uncertain. What are the rules then? And then we have supplemented this with detailed rules. And as I see it, the Digital Fairness Act will probably do that. It will give us more detailed rules on how to behave on the online market. And then even further, more details. Sometimes we see even that we have legislation saying you have to fill out this template. And when you fill out this template, then you will be in line with the legislation. Earlier on, the EU did not give any sanctions in their legislation, but they have started to do that. They didn't think it worked effectively enough, so they have started to say how the fine should be calculated and so on. So, and then we of course also see some private sanctions, but basically they have this more maybe collective protection view on regulation, and I think we will see more of that. Not so much the individual protection, but the collective protection. And collective protection is often sanctioned by fines. Yeah, that was just the starting point of, setting the mapping out of the consumer protection. Yes, like Joyce said, this is not a proposal, the Digital Fairness Act. It's not a proposal. It's not even a draft of a proposal yet, as at least what I know. But these thoughts about making a Digital Fairness Act is based on the findings of the fitness check. It showed gaps in enforcement and legal certainty, and of course also existing laws that address artificial intelligence and algorithmic decision making. So this is the purpose of the Digital Fairness Act, is to look at these gaps and see what can we do about them. And like Joyce said, this act is supposed to, and I'm quoting McGrath, your own EU Commissioner, Michael McGrath. He says this Digital Fairness Act is a missing piece of the puzzle in the European Union digital rule book. So it's supposed to be complementary. He's not going to change so much in what is already existing. So he's going to kind of fill out the gaps. And that's what I also say, that I think he's going to fill it out with more specific rules. So we know more specifically what they want to regulate. But it's based on the DSA Article 25 about dark patterns, but it's not limited to just dealing with dark patterns. But what the Digital Fairness Act will do more than the DSA does is it will widen the range of businesses under this new regulation, not just platforms like the DSA is regulating. They will have a broader definition of manipulative digital designs. I haven't seen this broader definition yet, so I cannot say anything more about that, unfortunately. And then, of course, they will have stronger rules to prevent ads that take advantage of psychological vulnerabilities. And here we have it again. So they look at the consumer as vulnerable, and you need protection. So they will make protective rules, not empowerment rules, as I see it. McGrath states that he wants to look primarily at 4 areas, and those are the areas that came up with where there was challenges in the fitness check that showed that. And together with these 4 topics, he says overall, they will also have special attention to minors. And he mentioned specifically the gaming environment that he wants to regulate a little better, so that our youngsters can safely use different games without being deceived and manipulated and so on. But he says subscription is a problem, mainly because it's very hard to get out of them. So it's easy to subscribe to something, but it is hard to get out. And here they're talking about, this kind of button that you can push, then get out button or something like that. So it's probably going to be very specific in this area. Yeah, then he says something about influencers, and this is because, at least in Denmark, surveys were made recently where they said, well, we are actually kind of good at identifying commercials when they come in our feed on Facebook. I'm a boomer, so I have Facebook, and the other youngsters have other things. But when you stroll on your Facebook news, you can easily identify this is a commercial, and you just stroll away. You don't even look at them anymore. And it's the same when you go online and see commercials and on the side of the screen. You don't even look there, because this is something you've built up kind of a filter of these. But then, of course, businesses have identified that this filter is not there when they use influencers as their marketing strategy. So here he wants to do something about this, McGrath, and he says this has something to do with transparency and also accountability for the influencers. So this is, of course, also going to be interesting to see what he will do specifically there. Then he has the whole profiling agenda going online, we are a target for profiling, and sometimes profiling can be a good thing because we don't want a lot of noise. We want what's relevant for us, but of course this can also be misused, and we can be deceived by this. So this is actually something I think he's going to have a little trouble with, because some profiling will be okay and other profiling tactics will not be okay, and he'll have to make a clear distinction there. And then we have the dark patterns and the addictive designs, and of course we will not. This is in line with the unfair commercial practices, manipulating and so on. Regards the addictive designs, just a few years ago, we had the rhetorics saying we are paying with our data. So and people didn't really care that much. This is my data. This is not something that, just take it. I have plenty of data. You can just take it all, and I can use the same data all over again, and so on. But now it has changed, and now we're talking about we're not paying with our data. We're paying with our attention, and that's a scarce source. So we have to protect our attention. And when they make addictive designs, they keep our attention focused in one place where maybe we would not have wanted to be if we had more of a free choice. So that's actually something that tips into both the economic interest, but also interests of well-being and you could say also maybe even democracy and everything. So where should our attention go? So that was a little bit about the Digital Fairness Act. What we were asked when they had the fitness check was quite very, very specific suggestions for specific legislation. I put some of them on this slide, and I don't think I have time to go through them all, but basically this is a mix of different things. It's a mix of, you could see the first one, they talked about easily understandable summary of the key terms and conditions, playing around with the fact we don't read contracts. I will get back to that a little later, but we don't read them, we just consent to them. Maybe it will be good if we had like 4 lines saying this is what the contract is about, so this is what you're consenting to, and so on. I don't know if we'll read them anyway, but and so on. Yeah, and then we have maybe a right to human contact or something like that. So I won't go into details because we have no idea if this is going to happen, but those maybe could be indications of what was going to happen. Yes. Then I would like to continue with a presentation of, or a small presentation of the guiding principles and model rules on digital assistance for consumer contracts. These are rules that I have made together with some other colleagues in the European Law Institute. Joyce mentioned it earlier. So these are not binding rules in any way. It's inspirational rules. It's something that we have tried to be proactive in an area where we think there's going to be a development, and why not try in the legal world to be proactive this time? Usually we are reactive, maybe. So what we are looking at here is when a consumer wants to use a digital assistant or digital AI to help enter into contracts. We don't see that much now, I believe. We see it from the other side. So we see businesses using digital assistants. When you go online and you order something, you don't talk to a person, right? You talk to their digital assistant. But we're trying to see it from the consumer point of view. And what we try to do here is, of course, say this is probably going to come. How then will we regulate this area? We're not saying we want it to come or doesn't want it to come. We're just saying if it comes, then we could look at it this way. So we have tried to look at the area from a contractual point of view. So both seeing the consumer as vulnerable, need of protection, but also actually granting them some rights. So we have both views, competent and vulnerable at the same time, and this is probably what we are, right? as consumers. So contract 1 is between the consumer and the digital assistant, or the provider of the digital assistant. So that's the you could say the digital service contract. And contract 2 is the contract that, with the help of the digital assistant, the consumer is entering into with, for example, a grocery store. So if we just take the example of, I want a digital assistant to help me buy my groceries, then the digital assistant will then, see what are my needs for groceries, and then they will enter into contract with grocery stores. And how do we go about then regulating this area? We have made 8 principles, and then from that we have made a lot of articles about model rules. So I will introduce the principles, and then I'll just introduce one small article, and then we can get back to it if you feel like it. Okay, so first of all, we have 3 principles that is basically about which law to apply and how to look at this concept. And what we have said is that we want to attribute all decisions made by the digital assistant on our behalf to the consumer. So even though you use a digital assistant, it's you. It's seen as you as a consumer making this decision. So that's the principle of attribution, you could say. And then, of course, if that's how the setup is, then consumer law applies to this contract between the consumer and the grocery store, contract 2. And also pre-contractual information duties, of course, also then continues to apply. We did discuss this about the pre-contractual information duties, because then the grocery store is actually giving information to your digital assistant and not to the consumer. So maybe we should change something there, but for now we have kept it this way. Principle 4, 5, and 6 is about the digital assistant in the market. So we're saying you have a right to use a digital assistant. You cannot discriminate against you because you use a digital assistant. The digital assistant has to disclose that it's a digital assistant. So you know when you're a business that you are dealing now with a digital assistant. And also we want to protect both actually the digital assistant as here, but we also have a piece of legislation where we protect the consumer against manipulation. There are several ways you can manipulate digital assistants, and of course also consumers. So principles 7 and 8. Here we have the control element, because if we attribute everything from the digital assistant to the consumer, then we want the consumer to have certain control of the contract. So of course the consumer has to be able to preset the parameters for the actions that the digital assistant will do. And also we have an objection model and a model of how to stop contracts that the digital assistant is about to enter into on your behalf. Lastly, the principle 8 is that the digital assistant has to disclaim if they have interests or specific deals with grocery stores and so on, in our example with the grocery stores. Yes, and then I will only go through one of our articles. This is Article 7. I think it's one of our more innovative articles. And the article regulates when a digital assistant is just about to enter into a contract with a grocery store on your behalf because of all the parameters you set into the system and so on. And then we can choose between different models. For example, the first model, confirmation model. Then the digital assistant says to me as a consumer, I'm about to enter into this contract. Please confirm if you want to enter into the contract. If you don't confirm, I will not enter into the contract. So that's the confirmation model. I have to do something actively as a consumer saying, please go ahead, make the contract with the grocery store of 2 milks, 1 sugar, and all that. The other model is the objection model. Here, the digital assistant will send you an email or an SMS or whatever saying, I'm about to enter into this contract. If you do not object within 3 hours or something like that, I will enter into this contract. So that's the objection model. That's the opt-out model, you could say. And then we also have a possibility of just saying to the digital assistant, I can't be bothered, just go ahead, do whatever you want. I will say that upfront, you can just enter into contracts. I don't want to hear about it, just you go ahead. So that's a third model, you can say. And the whole reason why we should use, or why consumer would use these digital assistants is, of course, to make life easier. So we have set up this Article 7 so that it can work maybe so that it will be easier, but you still have a possibility to choose a model where you still have some kind of control. Yes, so far so good. I'll keep a track of time here also. Yeah. So lastly, I will say a little bit about consent. And this is because this is an area that I have been wondering about myself. We consent to things all the time. We click boxes. We say yes to everything without knowing anything about what we are consenting to. And our whole society is based on contracting in different ways, right? And in the online environment, we do that even more. We click and we tap and we tick and we everything, and we really do not read the content of the contract or the content of the terms and conditions that we are consenting to. So there is kind of a dilemma or problem here that we are consenting, but what is it worth? It's worth a lot in law because you have consented, and this is a very important thing to do in law. But is it really worth anything if you don't know what you're consenting to? So yes, we are consenting a lot, different places. We're consenting as entering into contract. We're also consenting to waiver rights. This is something we saw earlier. And we can do it quietly. Usually we don't do it quietly in the online world. We do it actively, but you can call, is it ticking a box? Is that an action? It probably is, but yeah. And so on. So I won't go into that further. But what is then a valid consent? When can we say we actually have consented to something? Well, in the GDPR, they have what I have called the holistic consent definition. They have here requirements for when a consent is actually valid. It's when it's freely given. That means you have a choice. I'm not sure I have choices when I tick off boxes on online. It has to be specific and it has to be informed, and it has to be, and for a non-English speaker, it's a hard word, unambiguous. So there are requirements, and I call it holistic because it kind of takes into consideration all sides of the content. It has to be specific, right? It has to be even informed so you know what you're doing. It has to be freely and so on. But if you look at the consumer acquis, there's no definition of consumer consent. So when you look at the consumer acquis, and when I say acquis, I mean the consumer protection rules, they can talk about consent in different ways. They can say it as a formal thing. You have to have sent this written consent. It doesn't say anything about the requirements for consent, but at least here it's formally a written one. Article 16 comes a little closer to what I would call the holistic consent definition. Prior express consent, it says here. So if the consumer has given prior express consent, so it has to be expressly, whatever that is, but definitely something more, right? And it says here with the acknowledgement that he will lose his right of withdrawal. So here they expect the consumer actually to know the consequences of consenting. And now you could be a little, I don't know, what's this called in English, but at least you can be a little critical here and say, well, if I give my consent, hopefully you know what that means, right? You don't have to say it in this rule, but whatever they do. So but if they leave out express consent, if they leave out acknowledgement, then we're back to just consent, and we don't have any requirements for that other than, maybe ticking off a box. So that was a little on this, and then maybe I have a couple of slides more and go into the acknowledgement part. the acknowledgement must mean something about that you understand what this means if you're consenting to this. I don't think there is a requirement of understanding as such. But you could say that in the whole information paradigm, if you believe that if you give a lot of information to consumers, then you also believe, if you have this economic rational person in mind, then you also believe that they will read it and they will make decision based on that. So here, just underlying the whole consumer protection, you would say, of course, you are supposed to be able to understand what you're consenting to. Otherwise, you wouldn't, it wouldn't be a valid consent. But you can argue that. Also, I saw in one case regarding unfair terms here, the ECJ said, provided that the waiver, it was a waivering of the rights in the future, is the result of the consumer's free and informed consent. This is not something that they can read from the rules in the Unfair Terms Directive. This is something that the judges from the European Court of Justice here have said themselves. So we see maybe a tendency to try to qualify what is a consent. And my very last point will be a presentation of the possible agreement test that has something to do with consent. Because, well, the fact is that consumers cannot negotiate standard terms. Consumers rarely read standard terms. And if the consumer reads them, they do not understand them. So what the ECJ has said, or the EUD has said, well, if there's a standard term, the consumer do not read them. So in order to apply to the requirement of good faith, it must be determined whether the seller or supplier dealing fairly and equitably with the consumer could reasonably assume that the consumer would have agreed to the term concerned in individually contract negotiations. So basically here they are putting the risk of fairness to the business, saying you have to take responsibility for the consumer not reading anything, just ticking off boxes, and then it's your responsibility that this is a fair contract. Yes, so this is a mix between a paternalistic approach and a you could say a private autonomy approach. Yeah, that was all for me. I could go on for hours, as you can hear, but it would be very nice to see if there are some questions that we can discuss.